org. This is C-SPAN's America and the Courts. Sunday, Iraqis go to the polls to elect a National Assembly, while former leader Saddam Hussein awaits trial for war crimes. Earlier this month, two legal experts debated whether Saddam Hussein can receive a fair trial before the Iraqi Special Tribunal. The event was held at Case Western Reserve University Law School in Cleveland. Saying no, he cannot receive a fair trial is human rights attorney Curtis Doebbler, a volunteer member of Saddam Hussein's legal defense team. Saying yes, he can receive a fair trial is Case Western Reserve law professor Michael Scharf, a volunteer advisor to the Iraqi Special Tribunal.
I'm Hiram Chodosh, Associate Dean for Academic Affairs at the School of Law at Case Western Reserve University. On behalf of the Frederick K. Cox International Law Center and the War Crimes Research Office, welcome. The Cox Center is dedicated to advancing understanding and solutions to the most critical issues of global justice through our innovative educational programs, including a concentration of 35 courses, experiential and service learning in our clinics, labs, and externships, and study abroad programs, cutting-edge research through symposia on terrorism, the Middle East, intellectual property, nation building, and many other issues, and service to the broader community. Today's debate, the Hussein Trial on Trial, kicks off the Cox Center's newest program, the International Debate Series, which will feature an annual debate between leading experts on an important and timely issue of international law. Before we begin, a few points of background. As you know, on December 10, 2003, the Iraqi Governing Council approved a statute establishing the Iraqi Special Tribunal for Crimes Against Humanity, and Paul Bremer, the head of the Coalition Provisional Authority, signed that statute into law. The tribunal is charged with responsibility to prosecute those accused of crimes of aggression, crimes against humanity, war crimes, and genocide in Iraq between July 17, 1968, and when Saddam Hussein's Ba'ath Party seized power, and May 1, 2003, when President Bush declared the conclusion of major combat operations in Iraq. Only 4 days after the establishment of the tribunal, on December 14, 2003, U.S. forces captured Saddam Hussein. On July 1, 2004, Saddam Hussein was arraigned before an IST judge and informed that he was charged with 1. The systematic killing of religious figures in 1974, 2. Killing off the Kurdish Barzani clan in 1983, 3. Torturing and killing members of political parties over the last 30 years, 4. Using chemical weapons against the Kurds in Halabja in 1988, 5. The Anfal ethnic cleansing campaign against Kurds between 1987 and 1988, 6. The 1990 invasion of Kuwait, and 7. The drying up of rivers, killing hundreds of thousands of Marsh Arabs in response to their 1991 uprising. The U.S. involvement in the tribunal, the statute, and the selection of judges, the absence of international jurists, the fear of violence against inexperienced Iraqi judges and witnesses, the isolation of Hussein under heavily guarded detention, the availability of the death penalty, the emerging civil war, the collective conviction of Hussein's abhorrent rule in the court of public opinion, all raise a central question. Can Saddam Hussein get a fair trial before the Iraqi Special Tribunal? During the next hour, our own Professor Michael Scharf, director of the Cox Center, founder of the War Crimes Research Office, and advisor to the Iraqi Special Tribunal, and Curtis Doebbler, a leading human rights expert, one of 2 Americans, the other being former Attorney General Ramsey Clark, who are defending Saddam Hussein before the Iraqi Special Tribunal, will debate this issue. Doebbler will argue that Saddam Hussein cannot get a fair trial before the tribunal. Scharf will refute this claim. These two leading experts don't sit neatly in their respective adversarial positions. When he first learned of the Iraqi Special Tribunal, Scharf wrote that it would be viewed as a puppet of the occupying power. And Doebbler has spent most of his career representing the interests of people, including over 2 million people in the Sudan, subjected to the very type of abuse of which Hussein is accused. Both are committed human rights experts. Both seek justice for the Iraqi people and the broader international community. Each is here to contribute, albeit through heated disagreement, to our appreciation of the critical issues. The debate format today is simple. Each side, beginning with Mr. Doebbler, will have 15 minutes to make his argument. Mr. Doebbler will then have 3 minutes to rebut Professor Scharf's argument. In the remaining time, we will take 4 questions from the audience, 2 directed at Scharf and 2 for Doebbler. Each will be allowed 2 minutes to answer the question and 1 minute to comment in response to the other's answer. You have been provided forms to write your questions down during the debate. If you have a question, please raise your form in the air and they will be collected by our student assistants and brought to me for selection. The same process applies to those of you who are viewing the debate upstairs from our overflow room. Please supply your name and write clearly. And now, Mr. Doebbler, you have 15 minutes.
Thank you very much, and I want to thank Case Western Reserve University for being willing to host such a debate like this. There have been many other places who shied away from discussing this issue, although I think it is a very vital issue for human rights, and as I will try to display, a very vital issue for the values that underlie our society here in the United States. So I want to thank them very much, and to thank particularly Professor Scharf for being willing to join me in this forum. The first issue that has to be addressed when looking at the matter of the trials that may take place before the Iraqi Special Tribunal is the fact that this whole situation, the trials, what is happening right now in Iraq, the military involvement, the soldiers that are being killed, the civilians that are being killed, the destruction of Fallujah, all this has taken place in violation of international law. I have been to more than 60 countries after the invasion of Iraq in March 2003, and I have not met one lawyer that I even had to argue about the illegality of the invasion to, except in the United States. In every other country I visited, and meeting with some of the heads of state of those countries, and some of their most senior lawyers, they were convinced unequivocally that the United States' aggression against Iraq was a violation of international law, a violation of Article 2.4 of the United Nations Charter, which is binding international law on the United States. So we have to look at it from that perspective. In other words, think about it as if another country came to the United States, decided it didn't like President Bush and the Republicans in power, perhaps because they thought that President Bush was a war criminal for having committed crimes of aggression against other countries, invaded this country, and then alleged to put him on trial, saying that they would give him a fair trial. That is the situation right now that we face in Iraq. And I think it's important for us not to lose sight of that that is the crucial starting point. An illegal use of force against the territorial integrity and political independence of another sovereign country in violation of international law. Furthermore, even today, although some would say that there is still an ongoing use of force against the people of Iraq, there is certainly an occupation of Iraq of large parts of the country. That occupation is an illegal occupation, in part because it was based on an illegal use of force, in part because it is an occupation by a foreign power that has acted oppressively in the areas that it is occupying in Iraq. So the second important aspect to understand is that Iraq at least large parts of the country, are in a state of occupation. Legally, that means that there is law that applies to an occupier and how an occupier can treat the people of a country, how it can treat the institutions of a country. And in Iraq, the United States, I suggest, has not abided by that law. In fact, part of that law, the Fourth Geneva Convention, states that an occupying power may not dissolve the judicial bodies of a country and institute its own judicial bodies. The United States has dissolved the judicial institutions of Iraq, and it has instated its own judges. Yes, many of these judges were taken from among the Iraqi judges, and they vetted the Iraqi judges to decide which ones they would take. But they did not vet them for their competence legally. They vetted them in a process they called de-Baathification, a process whereby every single one of the judges was subjected to it, because every single judge in Iraq, with maybe an insignificant number of exceptions, were members of the Ba'ath Party. In fact, the most senior judges in Iraq were senior members of the Ba'ath Party. These judges were excluded from the judiciary. It is not a huge number, 180 of maybe 900 judges, but they are the most senior judges. The judges that are left are some of the most junior judges. Some of them were not even judges before and now have been made by essentially decree judges. These are the individuals who will be part of the court. Now, I'd like to go through each judge and say, this is the judge who is going to be in the court, and these are his qualifications or lack of qualifications, but I cannot do that. I cannot do that because I don't know who the judges are of that court. I know one person who is an investigating judge only because a television tape of the initial appearance in July leaked out. But that should not even have been made public according to the American authorities. And that person is a very junior judge, not a very senior judge. So we have a situation where the occupying power has created a tribunal of, in our opinion, less than competent judges that will be trying one of the most complex and possibly one of the most important cases in recent history. Certainly, I think that is inappropriate, but more importantly, I think that that is a breach of international law and the guarantees of a fair, competent, independent, and impartial tribunal. The court is not independent because it is created by an occupying power through a process by which the judges are chosen based not on their legal qualifications, but on a political vetting. The court is not impartial prima facie, in the words of the State Department commenting on South American countries, because faceless judges are prima facie an illegitimate form of judiciary. They violate the provisions of due process, the impartiality of a court. If there is to be a court in Iraq that tries individuals for international crimes, such a court must have the authority to try every individual who has committed a crime against international law in Iraq. That includes crimes of aggression, which are not included in the statute right now, despite what you heard about some of the allegations, and I will come to that in a second. That includes being able to try the nationals of other countries that may have committed these crimes. Probably not many of you are old enough to remember, but one of the greatest criticisms leveled at the Nuremberg process and the Tokyo process by one of the judges who participated in that process, Judge Rollings, a Dutch judge who participated in the Tokyo Tribunal, was that that process was not legitimate because it was only victor's justice, and in his words, that is not justice at all. If we are going to have a system of the rule of law applied to Iraq, if the occupying power and hopefully eventually a sovereign Iraqi government that represents the people of Iraq is going to deal with issues in their country that require a judiciary to deal with them, we need to have a fair judiciary established in that country. We do not have that right now. I want to go through some of the due process rights that are being violated and that need to be respected in this instance. I've mentioned some of them already, but because I know many of you are law students, I'll point out, although not the jurisprudence, we don't have time for that here, but at least the provisions of international law which are relevant. For example, what I've said already, many of you know that Article 14 of the International Covenant of Civil and Political Rights provides for a competent, independent, and impartial tribunal. It's also provided for in the American Declaration on the Rights and Duties of Man, which, although not a binding treaty on the United States, has been accepted many times by the Inter-American Commission as reflecting customary international law that the United States must abide by. And those of you who study constitutional law are certainly aware that the United States courts have said that customary international law is part of United States law. Also, the Geneva Conventions. Article 84, subparagraph 2 of the Third Geneva Convention applies the right to be judged by an independent and impartial tribunal. One has a right to be informed of the charges against them in a timely manner. That's in both the Third Geneva Convention, Article 104, and the International Covenant of Civil and Political Rights, Article 14.3a. The right to be informed of charges against you is not the right to stand before somebody who points out and says, "We think you have done many bad things," and even rails against you as to what these things are based on his perception or what might be public knowledge. It is the right to come before a court where you are presented with a prima facie case of facts against you, and where you are able to reply to those facts. And most importantly, it is a chance to understand what provisions of law you have violated. I don't know if any of you have seen, I've watched numerous times, as you can imagine, the process which took place in Arabic in apparently Baghdad, we're not even sure, that was filmed by CNN as the pool television station at that time. And not one provision of law was mentioned. In fact, at one point, the judge held up the law and said, "This is the basis of the establishment of the tribunal." And the president replied, "That's the criminal law that was enacted under my regime." He didn't even have the sense to open the book, the judge, and look at that criminal law and cite some provision of it. That, in my view, and I think the view of any criminal lawyer, is a travesty of justice. If you are brought before a criminal tribunal in this country, I hope that they will cite a provision of law that you have violated in any indictment or alleged allegations against you. I will not go through all of the rights. There are more than 20 rights that have been violated, but because of time, I just want to point out one or two important ones, particularly one that is important to myself as one of the counsel for the individual concerned. And that is the right to be able to have contact with a lawyer, and not just any lawyer, not like in Guantanamo, where the state decides who are the lawyers. I represent some individuals in Guantanamo Bay as well. And you know what the government told me? If I wanted to see those individuals, I had to sign an agreement stating that I would essentially tell the government anything that was mentioned in my communications between them. That is an inappropriate manner for somebody to respect somebody's right to legal counsel. That means a right to be able to consult with the counsel of your choosing and to be able to consult in confidence to be able to facilitate a defense. Seeing that the time is running out, let me just end then. And as you can see, it takes quite a long time just to get through the basic principles that are being violated in this case. But let me just end by mentioning that this is important, not only to Iraqis, who we are setting a bad example for by disrespecting or ignoring the rule of law, but it is even more important to all of you in this room, or at least those of you who are lawyers, because the law is based on respect for the law and respect for the rule of law for everybody equally. Thank you.
Thank you, Mr. Doebbler.
Let me begin by thanking Mr. Curtis Doebbler for coming here this morning, braving the winds of the Chicago airport and making it here for this. We met actually online because after I had written an op-ed piece in the Washington Post, there was an online discussion in which Mr. Doebbler wrote, "Dear Michael, I have followed your online chat with interest, even encouraging some of my volunteers to participate. Rather than debate your many wrong or misleading statements online, I would like to invite you to debate me in person. Maybe the Washington Post would sponsor such a debate, or maybe even your law school. As you undoubtedly are aware, I'm one of the lawyers for Mr. Saddam Hussein, and I'm intimately familiar with the proceedings in the case. Best regards, Curtis Doebbler." I wrote back, "Dear Curtis, I would enjoy very much a public debate with you. Would you have any interest in coming to Case Western Reserve University for such an event?" And here we are. The other thing I want to do is mention a disclaimer, and that is that although I have been lucky to be one of the 5 experts from around the world that have been chosen by the Department of Justice Regime Crimes Liaison Office in Baghdad to help train the Iraqi judges, and was over in London in October for a week working with those faceless judges you said now have a face to me. I need to start out by saying that I am completely independent. I'm an academic. I do not speak for the Iraqi Special Tribunal or the Department of Justice. Often they wish I wasn't speaking, I'm sure, because I'm so independent. And they're not paying me anything. I'm doing this because I feel very strongly that this is the trial of the century, probably the same as you, and I want to be involved, and I want to make sure that this trial does comply with international standards of human rights, and for that reason, myself and my students at this law school are helping with the process. Now, let me begin by responding to Mr. Doebbler's attempt to link the issue of the validity of the invasion in 2003 with the question of the legitimacy of the Iraqi Special Tribunal process. First of all, the Security Council of the United Nations, representing all the countries in the world, have recognized the legitimacy of the Iraqi provisional government, Iraqi's new sovereignty, the elections at the end of this month, and they have made a distinction between what some countries feel and some people, including myself, feel was an unauthorized invasion, and the issue of what to do next. Secondly, if the elected government comes into power and it approves the statute and the judges of this tribunal, there would be no issue of a violation of the Geneva Conventions, because that would sever any argument that this was a statute and a court that was set up solely by an occupying government. And third, your argument smacks of what is known in international law as the tu quoque defense. This is Latin for you also. And it is a defense that the Nuremberg defendants raised 60 years ago. It's a defense that Milosevic has raised at Yugoslavia and is almost always raised. International courts have always dismissed this defense as invalid. And the reason they do it is they say it is true that in wars and in foreign affairs, many countries violate international law. But when a tribunal is set up to prosecute defendants, the only question is, were these defendants guilty of the crimes charged? And the fact that other people may have committed other crimes in other situations does not excuse the guilt of these defendants. And therefore, the tu quoque defense is not a valid defense. It sounds great, but legally, it doesn't hold water. Now, with respect to judging the legitimacy of the Iraqi Special Tribunal, there is international precedent that gives us a guide for making this determination. And that comes out of the Yugoslavia Tribunal set up by the Security Council in 1994. And in their first judgment, the Tadic case, they looked at whether they were validly established and what it means to be a valid tribunal. And they said that it requires three things. First of all, international law requires that the tribunal be established by a statute, not just executive fiat. There has to be some controlling document. Well, the Iraqi Special Tribunal does have a statute. It's interesting to most people who read that statute that it looks an awful lot like the statute of the Yugoslavia Tribunal and the Rwanda Tribunal and the other international tribunals that have upheld the standards of human rights. Secondly, the Tadic case said that such a tribunal has to be independent from the executive and legislative branches. Now, according to the Iraqi Special Tribunal, it is independent. The president and the legislature of Iraq cannot control the Iraqi Special Tribunal, much like our legislature and president can't control our own courts. For evidence that this is in fact the case, I point out that Provisional Prime Minister Alawi, who is running for re-election, has been going on the campaign trail saying that the trial of Saddam Hussein and Chemical Ali will start tomorrow, or it'll start imminently. And there is quite a bit of pressure from him and others who would like to see these trials commence as soon as possible. But the Iraqi Special Tribunal said no. They cannot start because we do not yet have our rules of procedure. The Defense Council has not had time to prepare its case, and we will not and shall not be bullied by the executive branch because we are independent, proving, in fact, that the second element does exist for this tribunal. And third, these tribunals have to comply with fundamental norms of due process, which comes out of the Covenant on Civil and Political Rights, which you, Mr. Doebbler, pointed out. Now, next, you attacked the fairness of the Iraqi Special Tribunal process. And I believe in assessing the fairness of any tribunal, we have to ask ourselves three things. First of all, are there fair procedures? Secondly, are there impartial judges? And third, is there equality of arms between the defense counsel and the prosecution? With respect to the first of those, the fair procedures, those are set out in Article 20 of the Iraqi Special Tribunal statute, which is modeled on the Yugoslavia Tribunal statute and the Rwanda Tribunal statute. They will be further elaborated upon in the rules of procedure of the Iraqi Special Tribunal, which should be coming out after the elections and very soon. Now, there has been a lot in the press criticizing the Iraqi Special Tribunal, saying things like it will allow torture evidence to come in. In fact, that is the kind of thing that will be addressed in the rules of procedure, and it is premature to try to allege that that evidence will come in now when we have not yet seen the rules of procedure publicly. Those who have been working behind the scenes on the rules of procedure have suggested that they will be very similar to the rules that you see in other international tribunals and will be fully in compliance with Article 14 of the Covenant on Civil and Political Rights. Now, next, with respect to impartial judges, you said you don't know who the judges are. You mentioned that the only judge the world has seen is the one young judge, 35-year-old Judge Rod, who was the investigative judge, and you said it was because his image leaked out. Now, this is the one judge I got to know best in London because his English was the best. And Judge Rod told me the story of how his image was released to the world during the arraignment of Saddam Hussein on July 1st. He said that there was an option for them to electronically block out his face. But he said that he and his colleagues were so committed to the perception of fairness, that they didn't want this court to be seen as the kind of hooded judges that are in Chile and in Peru in the past and have been so criticized by human rights lawyers like yourself. So he said he was willing to take the risk to his security to have his face shown to the world, and that the other judges throughout the trial will do the same, notwithstanding the fact that there are threats against them, because they want to show the world how committed they are to fairness. And this is a situation where I didn't know whether or not I thought the Iraqi Special Tribunal would be fair until I saw him, I looked him in the face, I heard this, and I understood how committed they were, in fact, to being impartial and fairness. Now, who the judges are and who they are not. You mentioned that there were about 900 judges in Iraq. One of the things the public in the U.S. doesn't much know of is that Iraq was a very litigious society. There were actually 20,000 members of the Iraqi bar, 10,000 of which were in Baghdad itself. There were thousands of people who were judges and lawyers and prosecutors working on day-to-day matters that were not tainted by Saddam Hussein's special security courts. Instead, they were dealing with misdemeanors and non-political murder cases and assault and rape and sexual assault cases, torts and property matters. And these judges that have been selected, I have seen them, I have met them, they're not faceless to me. They range from the age of 35 for Judge Rod, who is one of the smartest people I've ever met, notwithstanding his youth, all the way up to the mid-50s. And these are people who have 15 to 20 years on the bench. Now, in London, we spent a lot of time going over the specific crimes of genocide, crimes against humanity, war crimes, and the crime of aggression, because these are crimes that no judges, no matter how much experience they have, when they are appointed to an international tribunal, they never have experience with this very unique area of the law. Even with respect to the Yugoslavia Tribunal and the Rwanda Tribunal, there were training sessions for those judges. And I learned through these training sessions, and also simulations we did afterwards, that they really understood the nuances of this law. I also learned that they were committed, very committed, to the possibility of acquittal. They said over and over again, if the prosecution doesn't prove its case, we will acquit, because we think that will prove to the world how fair this tribunal is. And I think we need to wait to see if that process works out. But it convinced me that these were people who looked me in the eye, were very honest with me. I could tell that this was something they were committed for. Now, there is an advantage to having Iraqi judges as opposed to international judges preside in this case. And that is that there's a myth of Nuremberg and the other international tribunals that the world will think international judges are more fair. In fact, the U.S. government did opinion polls in Germany after Nuremberg that showed that the German people, 85% to 90% of them, thought that the Nuremberg trials were unfair, that the judges were not fair, and that their defendants, Goering et al., were not guilty. Now, you could say, oh, that's because these were victor's justice. They were the U.S., the U.K., Russia, and France. What about the international tribunals? Well, the Yugoslavia Tribunal shows us what happens there with the Milosevic case, in which the Serb people have been polled, and they say overwhelmingly that Milosevic is not getting a fair trial, that these international judges are not fair, and they don't believe what's going on. Now, if you ask the German people today if they believe in Nuremberg and the guilt of their leaders, they'll say yes. And there is some empirical data that suggests that when that changed was in the 1960s, at a point when the German people started having their own trials of the Nazis who had not been prosecuted at Nuremberg. And this might suggest, I think strongly, that Iraqi trials by Iraqi judges are most likely to convince the Iraqi people of the crimes, if they're proven by evidence, in front of them in an open and fair trial, and that therefore they can move on, and this will build upon and allow the peace process and reconciliation to occur. Now, finally, with respect to equality of arms, the fact that you and Ramsey Clark are on the defense team suggests that Saddam Hussein, if anything, has the stronger side representing him against the Iraqi prosecutors who are arrayed against you. I have no doubt that every single procedural issue that possibly can be raised will be raised by this very good defense team that it consists of over 20 extremely good lawyers. They will raise them in front of the 5 trial judges. They will raise them again in front of the 9 appeals chamber judges. And Saddam Hussein will get his fair day in court. At the end of the day, if there is a mountain of evidence proved against him, and we have a record like the 22 volumes at Nuremberg, I think history will look back and say that Saddam Hussein, it was a tough case to try. I mean, obviously, when you're dealing with a Hitler, a Milosevic, a Saddam Hussein, or even an O.J. Simpson in the United States, these are tough cases to try. But the court, I believe, is capable of bending over backwards to maintain fairness. And the real challenge is going to be for them to convince the rest of the world that they are fair. Thank you.
Mr. Doebbler, you have 3 minutes to rebut.
Thank you very much. There's so many things to reply to, I don't know where to start there, because I think Mike has a very different understanding of the facts. But I must congratulate him, because some of these judges I and my colleagues have known for decades, and we are not able to evaluate their competence. After 1 week, you are able to determine that they will provide a fair trial. So I congratulate you sincerely on that foresight and ability to look into their minds. I must say, though, I would rather have my little sister representing me if she was able to have access to me, to talk with me, to bring me law books, to be able to facilitate some sort of defense, and even a lawyer as prestigious as yourself, if they tied you up and shipped you off to Siberia and didn't give you any contact to me and said, "You're my lawyer." That doesn't help. It's not a matter of who represents the individual. It's a matter of being able to prepare a defense. And the first criteria for that is that you have access to the individual. And don't take my word for it that this is an unfair trial situation. Take the word of the High Commissioner for Human Rights of the United Nations, the word of the head of the tribunal right now, the chief prosecutor of the tribunal in The Hague, the word of Amnesty International. They have all said that. I find somewhat whimsical this restatement, which constantly resurfaces from journalists and others, of this tu toku defense. We have never mentioned that defense. It only seems to be the other side that mentions it. Perhaps you want to raise that defense for us, but it is not something right now that is even being considered by the defense, except to listen to it from the other side. You may well have access to the judges. You may know who the judges are. But the point of due process is that, and the point of equality of arms, as you point out, is that the defense team and the defendant know these people and have access to them and have access to the evidence. It's very possible that there are, as the U.S. has claimed, 35,000 tons of evidence available. But we have not seen 1 ounce of that evidence. And I wish that one of you are sometimes put in a position, or I should say, I wish you never are put in a position of having to defend an individual when you have no access to that individual and no access to any of the evidence that is being used to allegedly prosecute, or maybe in this case better, persecute that individual. And finally, Michael raises the issue of polls. You know, before the Iraqi war, a poll that was done, I believe, by CNN, but you might correct me on that, it said that most people in the world where this poll was done, it was done in the United States and outside, believe Bush was a greater threat to peace and security than Saddam Hussein. Maybe we have the wrong guy on trial. Thank you.
Did you get questions? Good.
Well, I have some questions, and let me see if I can do my best at paraphrasing 1 or 2 of them. And the first question goes to Professor Scharf. You said that you had changed your opinion after your interactions with the Iraqi judges. But before, you viewed this as an illegitimate tribunal. Not everyone has had the benefit of those interactions. And because perception is as weighty as reality in determining the fairness of the tribunal, isn't it accurate to say that most people would view the tribunal as unfair, and by virtue of that perception, the tribunal is unfair?
I wrote a year ago in the International Bar News that went out to 70,000 members of the International Bar Association worldwide, that because the United States had been involved in the drafting of the statute, because they were involved in selecting the judges, and because they were involved in assisting the tribunal, that it would probably appear that this was a puppet court, and I was worried about that, and I argued that there should be international judges added to this in order to balance out that kind of perception. It wasn't that I just said that and dismissed this altogether, and I'm very committed to the idea of accountability, and there's many forms of accountability from international courts to domestic courts. What changed my mind in London was I found out a lot of things that haven't been publicly shared, and I tried to share this in my Washington Post Outlook piece a couple of weeks ago. One was that the United States did not dictate the terms of the statute. In fact, the Iraqis themselves were equal players in that, and there were certain provisions, like the provision on aggression, that the United States was not that in favor of, that ended up being put in there because of the negotiating process. Secondly, I found out that the United States did not dictate the death penalty. Turned out they were agnostic about it, but the death penalty was something that the Iraqis, who had always had it historically, felt was necessary if people were proved guilty of these crimes of this magnitude. And thirdly, I found out that the United States office in Baghdad was not being dictated to by Washington, but rather was given a lot of authority and was really committed to training these judges in a very neutral way and allowing them to operate very independently. And then finally, I've learned that the Iraqi Special Tribunal has held up to its independence against the Prime Minister's wishes that the trial proceed as fast as possible because they know a rush to judgment would be a mistake. I think when the world looks at those facts, those are good news for this tribunal, and there will be further things that are good news, for example, when the rules of procedure are promulgated, and we can all see what those are in the next few months.
Mr. Doebbler, a minute to respond.
Yes. I'm glad that Michael has such insight into this. We have contacts with several thousands of people in Iraq, regular contacts with them, and we don't know many of these things. I have had the opportunity to meet the gentleman who claims that he drafted not only the Special Tribunal statute, but also what is essentially the Constitution of Iraq that went into force on the 8th of March 2004. That gentleman is a Chicago lawyer. I've spent more time in Iraq in the last decade than he has. He knows probably less about Iraqi law than I do. Or sorry, I should say he knows probably equally as much about Iraqi law as I do. But more importantly, I think that the point that Michael is making is not that relevant here. It is not a matter of what he understands about the tribunal. Justice must not only be done, it must be seen to be done. And here it is seen to be undone.
Mr. Doebbler, we have a question from the audience. You have emphasized that Saddam Hussein's individual rights have been repeatedly violated, particularly his rights to due process. However, can you suggest any other legitimate means in which Mr. Hussein could have been brought to stand trial for the crimes which he is accused of perpetuating? If Mr. Hussein's individual rights are somehow superior to the rights of the millions of people affected by his actions, how can the Iraqis truly obtain the justice they deserve?
I think it's a very good question about how we bring leaders to justice. You should realize maybe the best way to answer that, particularly in my position representing somebody, is by analogy. There is an individual that we all know that threatened the life not of just 26 million people in Iraq, but 52 million people if you include Afghanistan as well. The president of this country. What he did, as I said, is almost unequivocally understood to be a violation of international law. I think that individuals who carry out those sort of actions should be punished. But I think that if we are going to punish Bush for his crimes of aggression, for his crimes against humanity, for his war crimes, even arguably in the situation of Afghanistan with his statements about the Taliban, saying first that it's a religious organization and then that everyone should be killed, even for genocide perhaps. I think we should punish everybody who commits these crimes. But if we are going to do it in a way that is better than the people who commit the crimes, we must do it with respect to the rule of law. We must do it with respect to due process. We must do it before a competent, independent, and impartial tribunal, not through some form of political vendetta, which is what is taking place right now.
You know, for my part, I am very much in favor of international tribunals when they are appropriate. But even the statute of the International Criminal Court suggests that they should be a method of last resort, and that domestic prosecution has many advantages over international prosecution. It is better to assist a domestic system where possible to have a trial than to try to move it into the international plane. And this is not the first time we've seen trials like this being assisted by internationals. In Ethiopia, after the Mengistu regime, the American Bar Association would help very much in the domestic trials of that regime and those leaders. As well in Rwanda, at the lower levels in the Rwanda courts, there are many members of the United States Bar who are helping as defense counsel and even as assisting the prosecutors and judges in those cases. And it can work. But as you point out, you have to bend over backwards to make sure that rights are complied with. Let me just very quickly respond to the two things you said at the end of your rebuttal. Access to Saddam Hussein. A lot of the defense counsel for about a year were complaining that they didn't have access to Saddam Hussein. Well, as of December 21st, you got access. The defense counsel met with Saddam Hussein, and my understanding is that that access is continuing. With respect to access to evidence, I have to ask you to be patient. This process is no different than the Yugoslavia Tribunal, the Rwanda Tribunal, or the Sierra Leone Tribunal. Until the process is set up, until the rules of procedure are set up, the next steps cannot be taken. But once it is set up, those rules of procedure will give you the rights to the evidence. You will have a Brady-like rule to see exculpatory evidence, and you will have many months to prepare your case, and I'm sure you'll do a good job.
I'm going to exercise my power as moderator in order to be fair and give Mr. Doebbler a minute to respond to that, since Professor Scharf went a bit over.
Well, thank you very much for that. Well, I hope we will get that opportunity. But again, Michael, I've expected you to tell me in the next sentence that you are visiting my client every day, because you seem to know much more than I do. We, as defense counsel, need that opportunity. The one opportunity that we had, actually, we had been told several times we'd have the opportunity to visit our client. We even told by Craig Keogh, who is the American there sort of supporting the defense or the prosecution, that only reason why we couldn't meet him is because we didn't have an Iraqi lawyer. 5 days before, I had received a letter from Pierre Prosper, the American ambassador at large for war crimes, telling me these are the Iraqi lawyers of your client. Something's wrong when they can't even get their own story straight. And we have not got another opportunity to meet them. In fact, we have been denied that opportunity, and we have been told that we will not get another opportunity to meet him. I think that is unfortunate. I think, in fact, that is a crime, a war crime, because, as you know, to deny an individual a fair trial is a violation of the Geneva Conventions, a grave breach.
Thank you, Mr. Doebbler. I have another question for Professor Scharf from the audience. Isn't the exclusion of all Ba'athist judges analogous to having a U.S. election or a jury selection process, but let's say no Democrats able to vote or no Democrats able to serve on the jury?
Well, I mean, ultimately what they excluded were the high-level Ba'athist judges, and in particular those who had served in Saddam Hussein's security courts, which were very similar to Adolf Hitler's courts that were subject to the Control Council Law Number 10 trial that was the subject of the movie Judgment at Nuremberg that most people know about. They did that because these people, in fact, were tainted. They perverted the rule of justice. Also excluded were people who had been in exile, and I was very happy to hear about that because I think those people had an axe to grind and they would not be capable of fairly judging. The judges who were included are not just low-level traffic judges. These are judges that have many years of experience with very complicated cases, not necessarily war crimes or genocide, but those cases are very rare, and no judges around the world have experience with those until they are assigned to international tribunals. And these judges are people that are neither too closely affiliated with Saddam Hussein or too much opposed to him, and they've been carefully vetted, and from spending a week getting to know them very well. And you do, I mean, it's different than a lawyer-client judge relationship. In a situation like this, it's like a seminar with law students. You're living at the same hotel, you're eating and drinking and getting to know these people, getting to know their social lives and so forth. And you can tell if there's a couple of rotten eggs there, you can tell if there are people who are committed to justice. And I think that whoever ended up doing the vetting process, and I know it was partly the Iraqi Bar, it was partly the Iraqi Provisional Government, it was partly the U.S. assistants, but they did a really good job in this case because the group that I talked to, I was very impressed with.
Mr. Doebbler.
Well, instead of looking at the reflection of an individual that's sitting across from me in a martini and trying to decide whether or not that individual is an appropriate judge, I look at manifestations that are in the public domain. And we know that the individual that they chose to head this tribunal initially was Saddam Chalabi, an individual who is on record saying that he wants to kill the individual that he is going to be trying. Would you feel that you're getting a fair trial if an individual who for a decade has been trying to kill you is the one trying you?
I have one more question for Mr. Doebbler. It has to do with the question of the invasion of Iraq. You've argued that the underlying occupation, the invasion of Iraq and the subsequent occupation were illegal, and that is a strong element in making the trial unfair. When is any invasion illegal if there is a dictator violating his own people? Question from the audience.
Yes. I think an invasion is illegal when it is against a country's sovereignty, its territorial independence, or its territorial integrity and political independence. Read Article 2.4 of the UN Charter, or if you want an interpretation of that, read the Nicaragua case from 1996. There are a lot of bad leaders in the world. As I said, if you're going to use this justification, that's a bad person, so we need to invade them. If we were to do that, even that, using that basis, on a consensus basis, it would have been the other way around. As I said, before the invasion of Iraq, more people thought George Bush was a threat to international peace and security than they thought Saddam Hussein was. And we probably know that's true now that they've found no weapons of mass destruction, nothing that they could say was a smoking gun. We invaded a country because we didn't like them. We better hope that for our foreseeable future, no other country is in that same position and remembers our president and is able to invade us for that same reason. And unfortunately, because of the political consequence of what we did, there are a lot of countries that don't like us right now.
Let me just say that the difference between the 1999 NATO intervention into Serbia to stop the genocide in Kosovo and the 2003 intervention into Iraq was that the emphasis was on self-defense and weapons of mass destruction as opposed to humanitarian causes. And I would have been much more comfortable had the United States said that we are going to have an international indictment of Saddam Hussein, we're going to get international approval, and we're going to invade him because he is committing atrocities against hundreds of thousands of people, and it didn't happen, and I agree with you there. Let me just say a final thing about Saddam Chalabi, because I think you just kind of threw up a straw man. As everybody knows, I think that Saddam Chalabi is no longer associated with the tribunal, but he was not a judge. He was not a prosecutor. He was just the administrator. His job was to do what a registrar does. And if a registrar says things like that, I think they should be removed, but I don't think that that shows us that this international Iraqi Special Tribunal process is somehow tainted. Thank you.
I'm going to give Mr. Doebbler one more minute to conclude, and I'll give Michael Scharf the last word since Mr. Doebbler had the first.
I just want to stress again that this is not a situation only for the people of Iraq, although it is mainly for the people of Iraq. We killed thousands of people in Iraq by the invasion of the country. And according to very reliable estimates, hundreds of thousands of Iraqis, at least, these are conservative estimates, are going to die in the next 5 years because of this invasion. That's more than died in that same period under Saddam Hussein, even under sanctions. But as I stated before, for an American audience, I think that this is crucially important because we have contradicted our own basic values, first by invading the country contrary to international law, and perhaps even more importantly, by now following that up with an unfair trial. And I hope that we will correct that quickly. Thank you.
Let me conclude by saying that after Nuremberg, there was hope that never again would mean something. And it didn't. Unfortunately, during the Cold War, we lived in an age of impunity where a person stood a better chance of being tried and convicted for killing one person than for killing 100,000 or a million. Now, luckily, we now live in a new age, a new dawn, the dawn of accountability. We live in an age where we see international tribunals and hybrid tribunals, and now we see things like the Iraqi Special Tribunal, which is a domestic court that is getting international assistance. And it's not just getting assistance from the United States. There are many non-governmental organizations around the world that are joining this process. And I think people have to ask themselves, do they want to be like the Secretary General and stand on the sideline and hurl criticisms? Or do they want to get involved and try to help the tribunal be as fair as possible? And I think, fortunately, having you as defense counsel is a very important ingredient. Having the Case Western Reserve University help the judges in providing guidance on very difficult questions will be helpful. And hopefully this system can go by so that Saddam Hussein will be seen as being tried fairly. And if there is accountability to be had, it will be had at the end of a fair trial. Thank you.
I want to, if you just hold your applause for a moment, I want to thank you, the audience, for coming to our first debate, the Hussein trial on trial. We will edit and post your questions on our website. I want to thank Professor Scharf for arranging the debate and for his impassioned defense of the tribunal. And I especially want to thank Mr. Doebbler for his very forceful arguments on one of the really most important trials of our day. So thank you all. I have a little modest gift for Mr. Doebbler, which is some things so that he remembers us as he's going back and forth to Baghdad, and that he have a clock so that he can set his various time frames, because I know he'll be losing a lot of sleep on airplanes. So thank you all for coming. Please allow me to escort our two distinguished experts out of the room, and I'm sure they'd be happy to chat with you out in our student lounge area. So thank you very much for coming.
You can watch this program and others